Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from LexisNexis, the family law imprint. Originally, obviously it came to us from Jordan's, but they've been taken over by LexisNexis. And I'm glad to say and report that the new publishers are continuing the excellent service they give us, which is to provide books such as this. And this one is actually on called the Financial Remedies Handbook. It's now in a 12th edition. It's been actually edited and written by Bird and District Judge Sophie Harrison. I find this particularly useful as a practitioner in the family courts because of the nature of family remedies, and obviously the whole problem with what was called ancillary relief in the past, but now is actually a financial remedy, can cause quite a lot of problems, because in many cases it does get down to negotiation, but it really does depend on what parties want. I've given for my review this title, A First Stop Paperback for Family Practitioners Involved in Financial Remedies, and that's what you're getting. And I think it's very good for a whole range of practitioners, people who have perhaps got more experience, and obviously they're using things like the Red Book and so forth, and for the newer practitioners as well. Let's have a look at the book first. Anyway, there it is. It's a paperback. There's the spine, you can see it there, and then at the back you can see there's a bit of blurb on the back. Now it runs into about 500 pages. The index at the back is by paragraph numbering, as you can probably see there. Now the paragraph numbering is quite useful because obviously you should be able to find things very quickly. It's only a very short index. I think it could have been expanded perhaps a little bit, but I found it helpful for what I've needed. Here is the information about the front page. Then there's the blurb from LexisNexis, and then there is the foreword to the first edition by Lord Justice Thorpe, and then in fact he has continued by giving a foreword for this current new edition where he updates it, and I've borrowed a little bit of what he says for the review. And in addition to that, Roger has produced a preface for the 12th edition, which I shall also mention in passing. And then we've got the contents section there. As I say, most of what will arise in your conferences with your clients is here. You can see it's a very detailed contents section. That can be read, of course, in tandem with the index, depending on what you're looking for. You can see, there we go, that's the end of the contents section. You've got right at the end a summing up, chapter 24, which is quite useful, and also for new people to the courts, some practical hints on preparing a case. I think that will be of help to the very large number now of unrepresented parties who may find this book helpful. We've then got a table of abbreviations, which again is very useful because of the number of Acts of Parliament and so forth. And then after that you've got the table of statutes, and then a few statutory instruments. When we get to it there, you can see those there, and then some European Union material, that will remain irrespective of Brexit. Then we got the list of cases. Of course, there are a lot of cases, and in fact the cases are quite useful. You can see the way we run through them there. They're quite useful because they cover all of the main points that crop up. Then you get to the book itself. Chapter 1, the introduction. You can see the paragraph numbering at the sides, and then there are some footnotes, sometimes more footnotes than others, but not very many. And I think that's quite useful because at the end of the day one doesn't want too much in the way of footnotes. I actually find it easier to just, when I'm going through this, to try not to get too bogged down with the footnotes, because as you can see here running through, there aren't that many. But all in all, a very important book. And as I say, the structure, there we go, the summing up at the there sets out how in fact one goes ahead, and then what you've got right at the back of the book is an appendix with some of the legislation. Again, it's all very useful and very much to go with the family court practice, the 2019 practice, the Red Book there. But this book is, I think, a standalone book in its own way, because it will be quite useful, depending on what is thrown at you when you have a conference with the client, and then you have to go and talk to the other side. So what do I say about the book then? Elizabeth and I talked about the book, and I wrote the review. She gave me some quite useful hints too, because obviously she's aware of the type of practice I have, and this area is quite important, although we do things slightly differently depending on each individual case. But for any practitioner in the family courts dealing with financial matters on the breakup of a relationship, this concise 12th edition for 2019 is, I think, just what you need as an essential work of first stop reference. And as I say, I think because it's pretty easy to read, obviously there has to be some knowledge of the statutes and the detail, but I do think it's relatively easy to read. The English is fine, and people, certainly unrepresented parties, should find it easy. So what I'd like to do is thank first of all LexisNexis for continuing to provide this title for us in a new edition to complement the Family Law series which they took over from Jordan's. You do make our professional lives a great deal easier. And obviously these are specialist books, but a big thank you to you. Now, the publishers sum this book up by stating the following: that by combining a clear explanation of the applicable legal principles with straightforward advice on practice and procedure, this is the essential reference work for busy family lawyers, family mediators, accountants and financial advisors. And I think absolutely that sums it up, and it does give you an indication of the people who need to see the book, because both Roger Bird and Sophie Harrison have brought their formidable judicial expertise to what is, I think, a most difficult area of practice, and they definitely cover everything a practitioner may need to refer to in preparation for or leading up to a final hearing. Now, some of them can be really difficult, where the parties are absolutely at loggerheads, but quite often, I have to say, they do crack at some stage and you can get some sort of agreement. Not always, but it certainly does happen. I've had a few like that, and I'm very pleased when they do settle, because it's much better if they agree amongst themselves rather than having it imposed by a court. Now, Lord Justice Thorpe adds some legal icing, if you like, to the legal cake, if I can put it that way. Writing. Now, for over a decade, he's contributed a foreword with several acute forecasts on imminent legal changes. And that's been going on, I'm afraid, for some time, not just in family law. Now, what Bird offers us here, of course, is scrutiny of the considerable practice developments and senior court decisions that have taken place. Now, Thorpe concludes with these words, which I thought were quite important, so I'm quoting them. Roger's survey of the ever-changing scene is not just completely dependable, but also enlightened by an insight derived from his natural wit and his experience of the evolutionary history to which he has made such a rich contribution as judge, teacher and reformer. Well, those are really fine words and absolutely true. And we would add that the sad passing of Julie Exton has left a void which has now been admirably filled by Julie Harrison from Reading. From the Reading Court, casting her benevolent eye, if you like, on the various aspects of the work, including her own contribution on procedure and pensions. And I think that's important to bear in mind. Obviously, it's always difficult when there is a change, and in the circumstances, very sad circumstances, obviously it can be difficult, but they've risen to the occasion, and thank you for the new edition. The 24 chapters cover all the basic questions which the parties will raise. I don't think there's anything really missing. I mean, there may be some odd stuff, but generally speaking, normally all the usual stuff is there, so you know what you're looking for. Do read, though, the final chapter on a summing up, which I indicated just before the appendices, which we feel would be of great use to those just embarking on the family law practice itself. And I'm thinking more of the younger members of council and solicitors who may find that of some help, because it can be quite a daunting experience. The family law jurisdiction is different in many ways from any of the other jurisdictions, and obviously the views by many are that if we could take much of this out of the court system, that would be a major plus factor, but it doesn't look like that's going to happen in any short time period, although mediation is taking over, and it's very much, well, I'm a mediator as well as a practicing barrister at law, the mediation side of it is very specialised. It's a main specialism. Now, the book, therefore, this one, the handbook, continues to provide us with an accessible short guide. That's together with the red book, which is behind it, in an area of family which remains of great importance, of course, to the parties, and is very significant to many people around them, including the unrepresented themselves. But it's not necessarily that easy to follow for the uninitiated without a little bit of help. But I've found quite often, even with unrepresented parties who then come to me, that they have a pretty good grasp of the basic rules, which are not too complicated. The sad thing about law is that there are one or two people out there who make it far more complicated than it needs to be, and that then causes more problems. But there again, we can try and sort that out. So what Roger Bird does, and he concludes the book by saying, as always, comments and suggestions for improvements from readers will be very welcome. So I do suggest you taking him up on the offer if there's anything that you think might be needed. For instance, I mean, I'll just give you one example. You might say, with say an application for a measure order, you might like to have that expanded a bit. That does come up occasionally, but there again, I mean, you're not going to get that stuff in the red book necessarily, but it will be very much dependent on the facts of a particular case, and that's really why the balance has to be achieved. Now, the law is as stated on the 1st of April 2019, and the 12th edition of this paperback came out on the 23rd of April 2019. Just have one last look at it. There it is, front, spine and the back. It's nice and light. I do see this book in the courts from time to time, just opening it in the middle. This is the Insolvency Act and the sale of the matrimonial home. That's actually one of the big areas. You can see how the book is structured, the paragraph numbering at the sides, and you've got case law mentioned, not too heavily highlighted either. And as I say, paragraph numbering, very little by way of footnoting. You do get the occasional footnotes in reference. There's one there, for instance, the reference to the Matrimonial Causes Act, for instance, in a specific section. But generally speaking, I think the fact that it's relatively low-level footnotes does help. Well, thank you very much to Roger Bird and District Judge Sophie Harrison. I'm very grateful to have this book, as most practitioners are, and I'm very grateful that you continue to give us such great support. Thank you both, and also to everybody concerned. Bye-bye.